Justin Baldoni has responded to Blake Lively's motion to dismiss, claiming the Me Too law doesn't apply to Blake Lively's fabricated harassment claims. We have employment lawyer Ron Zambrano here to answer your questions.
Hey, how's it going?
Good, my man. Thank you so much for being here on Popcorn Planet. I'm Andy Signor, and yes, he is back. So glad to have you straight out of the Soulja Boy case. You're making time for us. I'm honored. Thank you so much, Ron, for being here. Look, you had you last time as we went through this issue when Blake sort of put this up as her excuse. We now have Justin's reply, and a lot of people are still trying to figure out this 47.1 law. I know you've even looked more into it. It's new, but the vibe I get from all this is basically not a lot of people have really made verdicts regarding this law, this case law, and this could be very instrumental in this whole entire case. I wanted to get your overall thoughts. Before I do get there, I want to get here's Brian's statement in full. Miss Lively and her circle of Hollywood elites, I love that, cannot prevent my clients from exercising their constitutional right to petition the court to clear their names from her false and harmful claims. What Miss Lively is attempting to do is set a dangerous precedent by barring the courthouse doors to my clients and punishing them for having their day in court, a right protected by the First Amendment. This right protects not only Mr. Baldoni and the Wayfarer parties in this particular case, but all Americans in the future who have false allegations leveled against them and seek relief from our justice system. This must stop here, and we will continue to fight against this blatant attempt to block access to the court system and to weaken our nation's constitution to serve those who are in position of power. So he's really leveling in this sort of idea of, well, wait a second, she makes a claim of Me Too, and now we can't even defend ourselves? I guess I want to start there. What do you think? Do you think she has a case here? I know you've said previously, but now looking at it all together, what is your reaction?
The reaction is because of how detailed Baldoni's lawsuit with his own versions and the full text message threads and the full transcript of what was going on and these stills, I don't think she has a chance. What was very well argued by Baldoni's attorneys is that there has to be a showing of malice and well, now it's going to go back to her, to Lively. Lively had a reasonable basis for her claim in the first place. That's one. Two, it has to be on the face of his complaint. And what that means is that the judge reading the complaint in this motion has to assume everything that's in it and all those many, many, many pages is true. And then he makes a ruling. So what the judge has to read is go, okay, every single thing, these text messages, these allegations are true. The judge would have to make a determination that somehow she had a good faith, reasonable basis, and I don't think he can do that.
So is Brian's sort of quote legit? Like, do you think this is a massive threat to others? Like, is she trying to play this law, this Me Too law, which we're going to go through more depth, to like actually try and get her way? Do you agree with his urgency?
Yes, I believe she is misusing it, let's call it, in order for a underlying agenda and a fight that she picked that probably she regrets picking.
Yeah, I mean, you've always sort of said that, because we've talked specifically. Like we talked in our documentary, which stay tuned. We may be touching upon things that we touch upon there. That's fine. But the grade of this case, please don't hold back. But there's always been this other thing about like, well, the harassment claim doesn't even matter if it's true, because in California, if she levels a SH claim, as we call them, it's if he retaliated in any form, even after a harassment claim was made, he could still be found guilty. Correct? So even whether the SH was true or not, we already have to sort of contend with that. Is that true?
Right. So you have two things. One is the harm because of the act itself, and then the harm because you complain about the act itself. But there's a qualifier. You complaining about the act has to be done in good faith. It can't just be, just thrown out there just because. And it leans heavy on for the accuser, right? If the accuser just has any good faith basis for this, you cannot retaliate against her. So yeah, there will be viewed differently in two separate columns.
So this 47.1, I want to go back to this communications made with, as stated in civil section 47.1, with communications made without malice. Further provide that this section shall only apply to an individual that has or at any time had reasonable basis to file a complaint of SH SAH discrimination. These requirements that the communication be made without malice and without reasonable basis in fact, are why Lively's arguments fall flat. And as alleged in the FAC, Lively fabricated her allegations of SH either with wholesale or by exaggerated benign and not harassing interactions in a concerted malicious effort to seize control of the film and later restore her reputation after a well-publicized series of marketing missteps that sullied her reputation. What's also interesting is it does feel like the first time they're also even saying, yeah, now they hijacked the film and the franchise. They really are finally, it does feel like bringing all their things together here to reiterate like, well, yeah, these, because you've said it before, it's not harassment if it's just one of those claims, right? It has to be all of them under the same umbrella is what makes it more of that harassment claim. So do you agree with what they're saying here? Or do they have a better shot because of the attempted, effort to seize control of the film and everything else that he's saying here?
Right. So we've spoken like what Baldoni's alleged to have done is not like one super serious, like the boob grab, right? It's not that. It's these kind of like nefarious things which shouldn't happen in the workplace, but they have to happen over a course of time to meet the legal standard. Now, once this underlying story kind of comes up, her motivations for bringing these quote unquote unlawful things during those stories of them trying to take over the film now give context to his counterclaim. And I believe that it is a huge deal for the judge to see in order for the judge to make a determination. Now, what is very interesting and most people don't kind of understand is that the judges at this stage where they're just like, well, I'm just looking at your guys' complaints. The judge can't really make a credibility finding. He has to assume what is in the complaint is true. So that is why Baldoni's attorneys are like, this doesn't have a shot because of how detailed the complaint by Baldoni is. The judge cannot make an opposite finding because he has to or she has to make an assumption that everything in that very well detailed complaint is true, and it just can't happen for Lively the way she wants to.
Now, they also say here, because we got a bunch of questions to go through, but again, I want to reiterate, this section 47.1 has not been addressed in a single published or unpublished judicial decision. How do you think that's going to affect this court and this judge? What should we expect here? Could this be the first sort of decision on it?
A New York judge will not be deciding for the first time something serious like that. I think there's a possibility that the judge will punt it to the Supreme Court of California for them to make a decision on how to rule on the underlying facts. So let me say it another way. He may punt it going, what do the words mean in this statute? For me, as a judge in New York, with the Supreme Court of California's guidance to analyze these facts. Or what's going to happen is the judge will make a determination doing his best, and that the appellate court, if it gets to that point, in New York, will punt it to the Supreme Court going, hey, did we get it right? And that can delay things for at least 2-3 years, maybe.
Wow, it's interesting. That long.
Oh, yeah, for sure. I mean, there's no exigent circumstance, right? Like, there's no, like, national security. No one's freedom is being denied. It's a
so they could just stretch this on for years.
Yeah,
they probably.
Yeah, it's very common where another state is interpreting a sister state's law where that state goes like, we don't want to get it wrong. You guys tell us what to do. It's very common.
Okay, another question here based on this 47.1 out here. It by its plain language does not apply to the defamatory statements made on her behalf by her co-conspirators and agents, the Sloan parties and Reynolds. So does that mean that even if Blake's statements are protected, everyone else is still liable? Yeah. Especially considering the defamatory statements coming from Ryan Reynolds, calling him a actual predator?
Yeah, it's a very good legal distinction. This is very good lawyering by Baldoni's folks in that they're going, listen, even if Lively, let's suppose, we don't think so, but you're arguing that what Lively is saying in her papers is true. I mean, excuse me, what we say Lively is saying in our complaint is true and protected. Well, we have other people involved. We have Ryan Reynolds, and he's not protected by 47.1. So in the worst case scenario, Judge, he's still in for his conduct that is unlawful, and he's not protected under 47.1. It's very good lawyering.
They also bring up this Noerr-Pennington doctrine. I'm throwing this at you because I don't know if you got a chance to look at this, but it's mentioned a lot throughout. The draconian one-sided sanctions Lively demands are, in a matter of first impression, barred by the Noerr-Pennington doctrine, which precludes the imposition of liability for the exercise of rights protected by the petition clause of the First Amendment. Leanne, a popular sleuth out there with some expertise, sort of talks about this as well. But this law is a weird thing. Any reaction to this as well?
So I'm a little familiar with the Pennington doctrine, which every law student will remember with post-traumatic stress disorder. But the idea is that if there's a law that is designed to be punitive against people that are acting in good faith, it shouldn't be in the law. Now that requires a lot of factual distinctions. But on the flip side is there should be a lot of punishment for trying to suppress people from bringing claims of sexual assault or rape. There should be a punishment for people even attempting it. So there's going to have to be a balance. And again, ultimately, when this really does start coming before the appellate courts in California, the Supreme Court of California will have to ultimately decide whether the way the statute is drafted, and believe me, the people that drafted it already had this doctrine in mind, really complies with what that doctrine requires. I believe it does. I do, but I do see the argument. And ultimately, and again, this won't be for years where this will be resolved.
So overall in this, you do think Justin's still leading the win?
Yes, I do. I do think he's leading the win, and I will repeat, this is a fight that Lively probably did not understand how much it has exploded beyond her control.
Without a doubt. I want to. This article went viral because I think Blake's team wanted it out there because it was the first sort of lawyer I've seen put out a quote. Now, in Dina's respect to her, like, in the full context of this documentary, she's quoted, she's just more neutral, and she threw out sort of a scenario where Blake had the stronger case. But it seems clear Blake Lively's PR sort of threw this out. Here's was the quote. I'm just curious what you think. Attorney Dina Dahl says near the end of the documentary, my professional opinion, Blake has the stronger case because all of Justin's arguments about fame and control don't really refute her claim of SH. Those allegations, the improvising of kissing, the describing genitalia, talking about adult films, regardless of where your workplace is, those seem to be pretty strong basis for a claim of SH. What do you think about that? I guess your argument isn't really that those didn't happen. He's just saying that there's a different perspective, that they were really more consensual. Both sides absolutely want to get their perspective out. What do you think about that? Is that valid? Do you think that could be a win for Blake?
There would have to be a finding that the text messages and the full threads, right? Because there were things left out in her threads, in her quote unquote complaint, that doesn't have a showing that she also participated in the banter, right? So it has to be one of the elements for sexual harassment in California is that it was unwelcomed. It's in the verdict form. Well, it's an element of the claim. So these text messages that are in the full thread have an implication that she was welcoming this banter, which would not allow her to meet an element which makes the whole house of cards go down. So I disagree with this particular attorney.
So that's what I love, and attorneys disagree all the time, and that'll be what the casing is all about. But because all of that relevant info that Justin's put out in the evidence and the context and her using sexy, et cetera, all can come to play. I mean, we have now evidence now where Ryan Reynolds is seemingly admits that his 7-year-old daughter was cast as kid pool, saying, suck Wolverine's D off. And then the director's laughing. Yeah, she didn't even really want to do it, and we forced her to do it, and there were 400 versions of it. Many of us are watching that going like, my God, that's horrific. But yeah. Sexy was the line for Blake. Can all of that come into play, and do you think it will?
I don't think it'll come into play at trial. I think there's not enough of a connection between what Blake and Baldoni and Blake were doing. I don't think it's enough of a connection versus what ended up being decided on another film between two other people, even though one of them is kind of related. I think the judge will say that's too prejudicial because the reaction you and I just got, right? And then if the jury hears that, well, what does that really have to do with what happened between Baldoni and Lively? That's my opinion. Judges are very guarded with regards to things that are too emotional for people to forget what they're really supposed to be concentrating on.
Fair enough. But her saying sexy to Justin earlier, absolutely connected and relatable.
Yeah, for sure.
giving the that's what's so weird, because even as Dina was saying it, I do feel like a set on a movie is a different employment. It's like it's a different work. Like I've been there. I worked on a set of a Playboy TV show as the caterer way back, and it was clear the rules were different on that show than others, right? Because there's people walking around without any clothing and stuff. Like this industry is different than, say, a bank. So will the judge and jury be able to factor that into this claim?
Yes, if the lawyers bring out that narrative. Also, another thing, and I don't mean to open up this can of worms, but there's a lot of, if things are related to what's called the creative process. For instance, a comedian in a writer's room saying things that are offensive, but it's part
Right.
of the creative process for the show. That is actually protected speech under the First Amendment, but they haven't even got here yet.
So there's a lot they can fall back on. So
There's
okay,
so
so there
much
it
they
is.
can fall back on.
So Justin's arguments are strong. There you go, people. You got to hear first from Ron. Always appreciate you, sir, making time for us. I know you're a busy man, so thank you so much. Please, I don't know, check his cases out, whatever. Check it out.